Or someone did, shortly after the auction, buy the property for the prior $194,000. Doesn't that give rise to some reason to be concerned about the procedures that your client used?
No, Your Honor. The procedures here have been the historic process that have been used since the beginning of the Republic. But with regard to the particular $195,000 subsequent sale price, what we have is right now a discussion of the assessed value of the property on the open market and a later sale of the property more than a year after the property was purchased from auction, also on the open market, and not a sale within the confines of a forced sale with regard to the property. At the time of the foreclosure, there was no longer an open market for the property. We could not, there was not an unlimited time to purchase the property, and there was not the opportunity for there just to be a willing seller.
I am curious. I know this is a bit of a sideshow, for which I apologize, but I am curious about how come the assessor charged that tax again in disregard of the ALJ's at least oral indications that it was not owed. And how come nobody over the many years between there and here said, hey, wait a minute, what are we doing over a $2,000 tax bill?
So, Justice Gorsuch, there are a couple of wrinkles that occurred in this process. Number one, the decision with regard to the personal residence exemption was made by the township assessor, not the county. So the township assessor disallows the personal residence exemption. The property tax remains unpaid. The property tax is delinquent. So the property gets turned over to the county treasurer for the collection of the tax.
I understand that there are a lot of bureaucracies involved and that the right hand's not always talking to the left hand. I appreciate that. We've all encountered that phenomenon. But what is curious to me is we're sitting in the Supreme Court of the United States many years. No one, I mean, at some point the right hand recognizes, there's a left hand over here. And at some point, a lawyer gets involved and advises the left hand of the right hand. And I'm not criticizing anyone, don't get me wrong. I'm just curious how a $2,000 erroneously applied, it seems, $2,000 tax bill led to taking someone's home, a sale for a third of what it's worth, and then very promptly the whole value is secured again by the person who collected it out of the foreclosures. It's a striking set of facts. How did it happen? So
the township assessor, I don't know what the township assessor's reasoning was. It may well be. There's two requirements with regard to the principal residence exemption. There must both be, the person who's entitled to it must both be the owner of the property and be using the property as their principal residence. There may have been a question with regard to whether it was being used as a principal residence at the time. That is not in the record. With regard to after the property is turned over now to the county, who is the respondent here, when it's turned over to the county has no authority to say, now this tax should not have been paid, unless what happens is...
Oh, goodness. Really?
Unless...
nobody can say, hey, there was a mistake.
Well,
I have to foreclose on someone's home for a tax bill I now know is false, but I'm forced to do it.
So... Your Honor, the petitioner here had the opportunity to come to the show cause hearing or the foreclosure hearing, the show cause hearing with the treasurer or the foreclosure hearing with the court and say, this tax was never properly assessed. At that time, there is an opportunity to say the tax is not properly assessed. We're going to go ahead and reverse this whole process, and we're in the clear. But that didn't happen.
Is this always